Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. My name is Thomas Vick, joined as always by the co-host, Seth Wilson of Lifetime Legacy Lawyers podcast. Seth, how are you today?
Thomas, I'm doing great. It's a little icy around here. I don't know about your office place, but I was
Just rain. We just had rain at 34 degrees. Nothing froze. It was just the worst weather of all time.
well, I will tell you, I've not often had this experience where I try to pull into a parking spot going 1 or 2 miles an hour and my car will not stop. It just keeps sliding. And
Ooh,
so the parking lot was that icy this morning. And yeah, I had to be very careful not to slide into the car to my left or my right in that parking space. And it was so icy, in fact, my car would not go into park because it didn't feel like we were stopped. It just kept moving. It was
wow.
a Yeah, it was an adventure in Indiana weather for sure. I know we talk about that a lot at the outset of every podcast because it's the saying in Indiana is if you don't like the weather, wait 5 minutes and it
Or
will
just
change.
go to Greenwood. Just go to Greenwood.
Just a few miles to the south, so pretty amazing. But yeah, just that was a fun experience this morning that I hadn't had yet. I've been driving for a few years, so that was kind of fun.
Man. Well, I'm glad you're all right. Hopefully, things have unfrozen by now this afternoon as we're recording this podcast. As we were talking before we got going here, we thought it might be a good idea to kind of talk about the importance of deeds and the kind of effect that a deed can have on an estate plan. Let me just open up that topic to you, Seth. How important is it to make sure your deed is written in a certain way?
It really is, and it goes all the way back for lawyers to property class and understanding how the different types of real estate ownership is accounted for on the deed. And oftentimes you think about real estate as a bundle of sticks, and you can own all the sticks of the piece of real estate, or you can own two out of the three, or one out of the three, or so on. But how that is listed and recited on the deed, reflecting that ownership structure, is really important. And for example, there are deeds that I have seen where a man and a woman are listed on the deed and they're not married, but they say as tenants by the entireties or as husband and wife because they in their mind are married, but legally they are not. And there are some pretty significant legal ramifications to that distinction.
Yeah, maybe we could open it up by kind of asking what are the ways in which title to real estate can be held? I can think of about three of them right off the bat.
Yeah, why don't you start off with the tenants by the entireties?
Yeah, so tenants by the entirety is for a married couple, husband and wife situation where they both own the property, and because they're married, they I don't know, it seems like it's a step up in a tenancy with rights of survivorship. So the effect of owning property as husband and wife together means that when husband passes away, wife is going to be the complete owner of the real estate, and vice versa. When wife passes away, then husband's going to be the 100% full owner of the real estate. That's important to denote that it's husband and wife, John Doe and Jane Doe, husband and wife, are now the owners of the following described real estate. And it's important because that ensures the automatic transfer of title to the survivor and isn't necessarily determined by each spouse's last will and testament. So that's the first one. I'll let you take the next one.
Yeah, so the other types are you have tenants in common, and those tenants in common have different rights associated with the property, but there's not an automatic protection that there may be with the husband and wife, which also has some creditor protection built into it as well. And so that's kind of the strongest way. Tenants in common is just each person owns their interest. Each person has rights with respect to that interest in terms of, hey, I want to I want to get out of this interest. How do I do that? And we've talked in the past about partition actions and how you would go about severing that tenants in common interest. And so that's a fairly common way, so to speak, of joint property ownership if you are not married.
Yeah. And so we got tenants by the entirety, you got tenancy in common, then you also have joint tenancy with rights of survivorship. Joint tenants with rights of survivorship operates much the same way as tenancy by the entirety, and you don't have to be married for it. So whoever is the surviving joint tenant becomes the 100% owner at death. One interesting thing about joint tenancy with rights of survivorship is that you can sever that kind of joint tenancy with rights of survivorship simply by doing a deed. If if two friends own real estate together as joint tenants with rights of survivorship, and one gifts his interest away, then automatically the one who receives the gift, so to speak, is a 50% tenant in common, and then the other person is also a 50% tenant in common. And so it dramatically changes kind of the chain of title when each individual passes away. You're not going to have a 100% interest. So that can have a major effect on outcomes.
Yeah. And that's why it's so important as you think about your estate plan to understand the different types of ownership, how it's structured. And again, you may have thought you had a certain type of scenario and it may change on you because you were joint tenants with rights of survivorship, but somebody changed that and now you're tenants in common with someone you weren't expecting to be tenants in common with. And the survivorship provision may not carry out the way you thought it was going to carry out. And so when we talk about doing your estate plan, that's part of this, making sure that that piece of real estate or those pieces of real estate are transitioned the way that you want them to be. And so this question often comes up in terms of intestate succession because there are, as we've talked about before, different rules that apply to real estate interests than maybe we might think about in terms. However, with that tenants by the entirety deed, that is not as much a concern for individuals because that deed will pass to the surviving spouse and not be subject to their probate estate via intestate succession.
Right. And you can think of situations where maybe the wife is the sole owner of real estate and maybe she owned it prior to marriage and the title was never changed. And then, they get married, but title to the real estate never changes. And then what happens when wife predeceases husband and dies without a will? Well, then we're left with all of the intestate rules. There's going to be some kind of split interest likely between wife's children and husband. Husband will be able to get a portion of the estate off the top with the spousal allowance, and then some portion depending upon whether it's a second marriage and if there's children and all kinds of things like that. But a portion of the real estate will be available to him, but not 100% of it necessarily. That can you talk about things to argue about, that gets families arguing in a probate administration. So again, it emphasizes reasons why you need to have an estate plan in place so that house, that vacation home, whatever it might be, is going to be directed to the person that you want it to go to.
Yeah, and it just highlights the importance of proper titling of assets in general, not just real estate, because there are many times that you will look at a vehicle title, for example. And what if that was only in your own name and not yours and your spouse's? That has an impact or could in terms of how things are handled. And most importantly, it doesn't really reflect the intent of what you would want to do and how you would want to do that. And so that's why going through this process, we always encourage our clients to kind of, okay, this is a great time to look at everything and figure out how it's titled and is that the way I want it titled? And if it can be beneficiary designated, do I have those beneficiary designations done correctly? And do I maybe have my contingent beneficiaries set out the way I want them set out? Because there are, I can tell you very often you will see that first level beneficiary designation is done because I'm starting a new job, I'm filling out the retirement plan application, and I'll just put my spouse on it. We'll deal with the kids later. Well, later maybe never gets there. And
Yeah.
so you get to a point where you came back 10 years later and realized, "Oh, I haven't listed the kids." And hopefully nothing has happened and that hasn't caused an issue for your family. But at the same time, it's just a good time as you're thinking about updating your estate plan to go through all these other assets that are there and figure out how best to title them.
Yeah, absolutely. Good reminders there to update beneficiary designations. Another topic that we kind of talked about prior to the podcast was, what do we do when a trust isn't working out the way that it's supposed to? What happens when there are some difficulties in administration? What are some options that are available to a trustee to kind of solve some of the administrative problems that a trustee sometimes does run into?
Yeah, great question. And first and foremost, you got to look at the trust and determine what options are built into the trust, either via a trust protector provision or some sort of amendment provision, or an impossibility provision. Maybe the trust is too small to keep it in trust and you need to move it along. So the trust will have some language typically that addresses the scenario of, boy, this wasn't a foreseen circumstance. How do I address that now? And then if that doesn't work and there's some interpretation that needs to take place of the trust, you can actually request a court or a judge to give you instructions as the trustee as to what should be done. How does the court interpret this provision as it applies here? And you have to give beneficiaries notice and opportunity to be heard as a part of that process. But you can actually lay out, maybe you and the attorney look at, hey, these are the scenarios that are going on and this is kind of what we think the trust was meant to do. We just want to make sure we have permission to do that so the trustee doesn't breach his or her fiduciary duty to the beneficiaries. And so you give everybody notice and you say, here's the petition outlining the requests of the court. Give folks an opportunity to be heard on that, and then the court can issue instructions as to, yes, you can proceed, no, you can't. Hey, I like your situation here, but that's not exactly what I think the trust says.
The theme of this portion of the podcast is, it's better to ask permission than forgiveness, right? You have this forum in which you're able to ask a judge what you're supposed to do, and you can kind of set the issue before the court and let the court direct you how you're supposed to go. And I've done this at least a couple times in my practice where there was some issue that has the trust just not feasible for whatever reason. It might be an issue with who was named as trustee, so you get a trustee to be named by the court, essentially. That may be a reason. Or maybe, there are some issues that are happening with the trust funds that make it kind of wasteful to continue the trust in accordance with the way that it is currently written. And so, it might be that you can tell the court, if we continue to do what the trust instrument says, the grantor of the trust had great intentions, but it's actually going to cause wastefulness, and the court doesn't like wastefulness. So let's amend this and maybe allow distribution sooner rather than what the trust actually mentioned. It's kind of not intuitive to us as estate planning attorneys who say a trust is going to avoid probate, and here we are on a podcast talking about how a trust can actually be placed before a probate court voluntarily. But again, it's because we're asking permission rather than forgiveness. We want to settle these things in a upfront manner so that the beneficiary, upon receiving a trust accounting, says, well, why did you do this instead of that? And why did you make that decision? We can just put everything in front of the judge and let the judge make the decision. We'll have good reasons for doing that. And if there are, if it's ultimately not a good idea, the judge will say, no, you shouldn't do that. Continue to, and that's great because the trustee gets an answer and direction about how to proceed with the administration. So it's
Yeah.
better to ask forgiveness than permission.
Yeah, I was just gonna tag right onto that, which is that prevents a situation between the beneficiaries and the trustee. Because if the court gave the permission, that's the final word on the subject. And that allows the trustee to move forward with confidence as to that proposed course of action. And most of the time, these are pretty rare that this actually occurs. Typically, there's a significant change in circumstance that was not foreseen, or there's been something more, maybe the trustee wasn't doing what it should have done, or maybe like you said, we were using a corporate trustee and the fees associated with managing the trust fell below a threshold that it made sense to continue to pay that corporate trustee to do that. And so maybe it was, let's have somebody else appointed as the trustee who can manage these funds for a lower cost to the beneficiaries and to the trust. And so there's a myriad reason for potentially this situation happening, but it doesn't happen super often. And a lot of times it's more, hey, we've got a beneficiary class that doesn't exactly agree on a proposed course of action. So let's get that answered firmly for everybody. Make sure everybody had a chance to speak into that in keeping with the intent of the trust before we take action.
Yeah, absolutely. Absolutely. I think last podcast or maybe two podcasts ago, we talked about, what was it? Non-judicial settlement agreements for a trust where if everybody agrees, there are certain categories of issues that can be resolved without going to a court. Well, there are some issues that cannot be resolved without going to court. So this is kind of in that category. You could ask the court for anything really, but there are certain issues that you absolutely have to ask a judge to do. And if there's going to be a substantial amount of money involved, probably is better to go ahead and get a judge's decision on it rather than trying to do it with a non-judicial settlement agreement.
Yeah, and you also want to be cognizant of any no contest provision in the trust itself and ensure that the action that you're proposing or the clarification that you're requesting isn't something that's actually contesting the trust and hurting a potential beneficiary, or you're making that action and request with full knowledge of, if this is considered a contest and there's a provision saying you can't contest this or you forfeit the share that you would receive, that's an informed decision by whoever would be proceeding under that course of action. Again, I haven't seen a lot of those in my practice, but there are times when that becomes a factual determination as to whether you're going to file a petition with the court to determine those instructions, because it could be seen as contesting that share that you're going to get. And if you're unsuccessful, you forfeit the share, hence why the no contest clause was put in the document in the first place as an incentive not to do that.
Yeah, and if that no contest provision is invoked, somebody's not going to be happy. Somebody's not going to be happy at all. So that would be a bad day. So
That's
yeah,
right.
you definitely want to make sure that you're not going to be invoking that no contest provision. That's a good word of education there, Seth. Anything else that we want to cover before we let everybody go on the podcast?
No, I think those were the two kind of hot button topics I was thinking about this week. Of, it's just so important to understand what your interests are and how you want to make sure that your intent is carried out. And the two examples that we talked about today kind of highlight those two ends of that spectrum, where you can have your deed and that will take care of a lot of the situation, and you can have a trust on the other end. But even with the trust, every once in a while there's some lack of clarity there into how it's supposed to work. And again, I mentioned most of the time that's because of unforeseen circumstances. So we talk a lot about planning for what we know and can reasonably anticipate. And sometimes we just don't know. And sometimes we didn't anticipate this ever happening and it was outside the normal. So we have to address it as it comes up. So I thought that was two good examples today of just thinking through, making sure that your intent is carried out.
Good stuff as always. What is the best way for people to get in touch with you?
Thomas, our web address is adlerattorneys.com, adlerattorneys.com, and that'll take you to a contact us page, and you can fill out that form or give us a call, and we'd be happy to answer any questions we can for you. How about yourself?
Best way to get in touch with me is by going to viclaw.org and book a call, viclaw.org, and book a call. Got a lot of resources there for individuals to check out for estate planning and elder law. So I point people in that direction. And as always, this is the Lifetime Legacy Lawyer podcast. Check us out on YouTube and all the different places you can get your podcasts, and hit the subscribe button on YouTube.
That's a great reminder. I'm not so good at reminding people to do that, but yeah, I enjoy YouTube a lot. It's a lot of fun, and it's often a rabbit hole you can go down to, so you have to be careful there. But you can add us to some sort of playlist or subscription and watch when you have time. And hey, helpful hint: you can even listen to it on double speed if you want that way, and really speed up our voices so we
There you
sound
go.
like.
Make it sound like we're from New York and not Central Indiana.
There you go. There you go. Well, Thomas, thanks as always, and we'll talk to you next time.
All right. Take care.